Once discovery has been concluded or it's reached a place where each side knows enough to go to the next step, oftentimes what happens is there will be a mediation. And what that is when the parties come together and they have a conversation about trying to get the case settled. And that is done with the help of a mediator. Now, a mediator is typically a lawyer, oftentimes a former judge, that is not involved in the case. They're a neutral third party. And the mediator's job is to facilitate a conversation between the sides with the ultimate goal of trying to get to a place where we can agree to a settlement. And so what happens at a mediation, and sometimes they're done in person, sometimes they're done remotely, each side will be involved. So say, I'll be involved and my client will be in my office, and then the defense will be involved, defense lawyers, insurance companies, whoever else, and then there'll be a mediator as well. In a mediation, what happens is initially I'll make a presentation about the case. Oftentimes we do PowerPoint presentations and we tell the story of what happened, why it happened, the causes, and then also the injuries and damages in the case. So I'll make this presentation and we make a demand. And then that's an opportunity for the other side, the defense, to then make their presentation in the case. And we sit and we listen to it, and the mediator is listening along the entire time. And then once those initial sessions are done, we go into different rooms and the mediator will go back and forth. Oftentimes he or she will start with us, have a conversation, and get to know you, the client, a little bit better, maybe ask some questions about the case. And then once they get to a certain point, then they'll go to the other side and talk with the defense, have the similar conversation, and they'll get a number, essentially. They'll say, defendant, what is it that you want to offer in response to what Mr. Callahan has demanded in the case? And the mediator will get a number and come back to us. And then we make a counter demand. And so it's a back and forth process that can take half a day. It can take an entire day, sometimes longer, with the ultimate goal of trying to resolve the case, which means settling the case. So if a case is mediated and it can't be settled, what happens next? Well, at that point, it's time to take further steps to get ready for trial. Ultimately, if a case cannot be settled, the parties will go to court and present their case to either a judge or a jury, and that can take a day, that can take a week, that can take a month, depending on the case. And ultimately, the goal is for each side to present their side of the case so that the jury can then deliberate and make a decision as to who's right and what the value of the case is. So at the conclusion of a trial, the jury will do what's called render its verdict. They reveal their decision to the court. And the decision is read in open court, and each side sits there and listens to what the jury decided. And let's assume that we present our case and the jury agrees with us and they award a certain amount of money, $1 million, $5 million, $100,000, whatever it might be. The next step is us to file the appropriate documents with the court so that we can get a judgment. And a judgment is a piece of paper or several pieces of paper that list out and describe kind of what happened during trial and what the jury found. And ultimately, with interest and everything else, what the total amount that is owed to the plaintiff. So the next step is that we deliver this judgment to the defendant, and a couple different things can happen there. Number one, they can pay the judgment. Number two, they can say, okay, we understand what this judgment is, but we want to negotiate this. Because the truth is, insurance companies are always trying to negotiate and always trying to save some money. So let's say we get a judgment and it says $1 million. And the insurance company, after we have that judgment, after that's what the jury decided, the insurance company then wants to talk again and go to another mediation. And they want to come in and try to have a discussion to try to pay less than $1 million. And each case is different. Sometimes we negotiate, we get the thing resolved. Other times we say, no, this is what you owe us. And then it's up to them to decide what they want to do. And another possibility is that one side or the other does not like the results. They don't agree with what the jury decided. They don't agree with the judgment. And at that point, what happens is that one side or the other has the right to file an appeal. And what that entails is putting together the documentation and getting a copy of the record from the trial and everything else, putting it together, and then filing that with an appellate court. And that starts a whole new process where the appellate court will then review the case and make a decision as to what should happen next, whether to overturn the case, to say, parties, you need to go back and retry the case because there was a mistake made sometime during the process, or the appellate court could say, well, golly, we agree with what the jury decided, and we agree with everything the judge did, and there are no mistakes, and this judgment is final. So if you have any additional questions about the timeline, how long it takes, how long it can take for a personal injury claim, please don't hesitate to contact us at the Callahan Law Firm. And you can do that by going to our website, and that is www.thecallahanlawfirm.com, or you can call us at 713-224-9000, and we'll do everything we can to answer your questions to help you understand how long the case can take, because every case is different.